Brilliant. Thank you very much for that. So hopefully that's now moving forward. Apologies for that slight technical hitch, and we will continue on with the webinar. So welcome, and I am Kelly's business partner. Often, obviously, Kelly does these webinars, but occasionally I do like to dip in and throw things into the mix with a little bit of technical issues to keep you all on your toes. We are based on the Harwell campus in Oxfordshire, and Kelly and I set the business up just about 7 years ago now. And we've got a great passion for data protection and engaging people in making sure that they can understand how it applies to them, their daily roles, what they're doing, and that they feel confident to use data in a way that's going to be really supportive and helpful for their business, rather than feeling that it's something that is preventing them from doing what they need to do, from achieving their goals, particularly around business growth. And I know that was one of the frustrations that people had when GDPR came in. They were fearful that they weren't going to be able to continue to make new connections, to market to people that they felt would be interested. Often is the case, some people aren't, and that's okay. And we can discuss how you can determine that and the decisions that you can make as a business, whilst bearing in mind the right to the individual to have privacy and that respected in the way that you use their data. So what we'll do is to go through some of the things that Kelly and I heard routinely in certainly the 2.5 years since GDPR came in, as to how it affected what we were going to be doing and what you could as a business do when you were running events and talking to people. And we'll take those myths and hopefully bust them a little bit for you so that you can feel confident you can do what you need to do, but in a way that's compliant with GDPR. So one of the ones that we heard very frequently at networking events was that people felt that they couldn't take photos. They were aware that photography obviously works and uses people's personal data. It's your image, so therefore it is personal data. You can identify an individual. And they felt nervous about actually taking those photos, using them in a way that would be good for marketing purposes, because they weren't sure that they were able to do it. And actually, when you look at it, there's ways that you can manage it. So you are able to take photographs and have a photographer at an event. If you think about big public events, big conferences, anything large that we used to run, obviously prior to the COVID issues, you are able to take those event photographs. People are in a public place, so there's an expectation that maybe they might be photographed. In addition, you don't need to get the permission of everybody in the photograph. That's not practical, but there are ways that you can make sure people are aware that photography or television filming or video filming for marketing purposes is actually being used. And you can do that through notifications on tickets. You can have it on notices up on around the walls so that they're aware that there are people around who will be taking photos. You can ask them at the point of sign up if it's a more smaller event, that are they okay with photos being taken? If they're not, then you can give some kind of indication, a little dot on their badge, or that they don't want their photograph to be taken. Or you can just ask the photographer to let people know when they're taking general shots, and just ask anybody who doesn't want their photo to be included to step to the side, and that's absolutely fine. Certainly, if it's the focus of the photograph is an individual or two individuals, you can then actually ask them and say, are you happy we're going to use this on our social media, in print format, in a magazine, whatever you're going to do, and just flag to them that they are being taken a photograph of, and the purposes for which you intend to use it. And typically most people will say yes, but if they don't, then that's fine. They can step outside of it, particularly if it's like 2 or 3 people together. I've seen a question there about Zoom meetings and screenshots of those, and absolutely that's a very COVID relevant question with the way that we're working now. And I would absolutely, again, just let people know that they are going to be photographed and that their image is going to be captured, so that you can give them the opportunity to turn their camera off if they don't want to be involved. Similarly with recording a webinar, we will record this one, but nothing that you type in the right hand side will be captured. I'm simply capturing the actual screen and my video so that we can use that on our online presence. So it's again about transparency, being clear with people about what you're capturing, why you're capturing it, and if possible, giving them the opportunity to step aside. You don't necessarily need written permission, because you're doing it based on kind of a legitimate interest of you want to demonstrate what your networking event is doing. And if you're giving people the opportunity to just switch their camera off, it's more of a opt out rather than actually trying to get written permission from everybody, which often isn't practical in that type of an event. So moving on from that, the other one that we often heard that was, there's a big focus on consent, and there was a real kind of worry that you can't actually exchange business cards without actually having consent, and some kind of like, yes, I can contact you with marketing materials. It's absolutely true. You do need a legal basis for why you're processing their data. Business cards are data, and you're likely to take them back and pop them into your CRM system so that you can follow up on the lead. But it's about the fact that you as a business are trying to engage with new prospects. You're trying to identify people who will be either a good customer for you or a good partner for you. And in that sense, that's the reason that you're at the trade show or the networking event. And similarly, that's probably why they're there as well, looking for businesses that can help them. And so there's a mutual interest there, but your legitimate interest is about identifying new customers, growing your business, and you're using those events to do that. That exchange of business cards and then the follow-up communication that comes from that is based on that legitimate business interest of growing your business. Now, what you don't want to do is to have a whole list. If you get shared lists at networking events, again, that's fine. It helps you to contact people that you might not have had a chance to share a conversation with. Again, it's about using that data appropriately. So following up with a LinkedIn connection or an email to say, I really would be interested in finding out more about you and telling you more about my business. Can we have a conversation? But what I would implore you is please not to just add people to your newsletter lists. That's unlikely to win you friends anyway. And that really, newsletters and that kind of engaged routine marketing really should probably be more on a consent basis than legitimate interest. So certainly at that prospect stage and business card exchange, you can absolutely do that. And that's where legitimate interest comes into it. So we've always got, and just to flag here really, that kind of dynamic between consent and legitimate interest. And consent has seemed to be this, I hear all the time that we must have consent to process any data, and that's simply not true. There are 6 legal bases on which you can rely to process personal data. Nothing is better or more solid than anything else. Some gives more rights to you as a business, and some will give more rights to the individual to stop you from processing their data if they don't want you to. So consent and legitimate interests are very much the individuals have more power over how their data is used. Contractual and legal obligation, obviously as a business, you then have a need or responsibility to process that data, and it's often more appropriate. So for example, employees, you will never need, generally speaking, to have their consent to process their data. It's always going to be legal or contractual, whereas where you're engaging with consumers, where you're engaging with other businesses, for marketing purposes, you really are going to have to look at what's most appropriate. Is it consent? Is it legitimate interest? And then where you're balancing that up, it's really about understanding what is your legitimate interest. So are you trying to connect with new prospects? Is it about engaging with previous clients? Have you had a relationship with these individuals before? Are they brand new? And all of those things will really impact on that decision that you make. So consent obviously is very explicit. You need to make sure that people have responded, that it's clear what you're going to do with it, that they've actively said yes. And legitimate interest is more about you identifying and saying, this is what we want to achieve. We believe it's in our interest as a business to achieve this goal, objective. And without intruding on another individual's privacy, we feel we can send this communication to them or send them information in this way, or use their personal data in a way that isn't going to intrude on their privacy too much. And often this is in the marketing arena. Now, I know you'll remember back when GDPR was introduced, a lot of organisations were relying on consent previously, and they tried to get reconsent either because their records hadn't been very good, or that they'd never properly asked for consent. So they went out to marketing databases that they had and tried to get that actual active consent. Now, a lot of people didn't bother answering, partly because they were overwhelmed, partly because probably they weren't interested. And so lots of marketing databases were slashed in terms of volume, which clearly concerned a lot of businesses because they felt they're not going to be communicating with people that they really want to. So subsequent to that, a lot of people switched it to legitimate interest. Now, technically, you have to look at it from the point of view at the beginning and say which is the most appropriate basis to use, rather than flitting between the two. But sometimes it will be consent, and in that case, you do actively have to get the individual's consent, and they can withdraw. Other times, you can look at where it's appropriate to say we've got a relationship, we've got something that's similar that they may be interested in actually engaging with, in which case we can rely on legitimate interest, and that will sit around growing a new service, but it's related to what you've already done, growing the business in a particular area, and all of those things you have to just check whether or not it's going to be intruding on an individual's privacy. Now, business and consumers are going to be quite different. If you're business to business, the intrusion on an individual's privacy is less, whereas in a consumer, it's likely to be much higher, and you've got other considerations to think about. This is one that's always quite interesting, and again, it's kind of comes out of that over-reliance on consent where it's not the right legal basis to actually use. So this one, it's a real life story that a friend of mine told me, that people who had gone out and asked for consent, if individuals, if their customers hadn't given them consent to contact them for marketing purposes, they translated that into any consent at all to email them about anything, which meant that their members, so in this case it was a leisure centre, they were doing works in their changing rooms and the facilities, and they didn't email their members to tell them who hadn't given consent, but the consent had been for marketing information. So they just blanket applied that across the whole use of their email address, essentially. And so that's incorrect. So you might have one piece of data, in this case their email, where you might use it for multiple purposes. And in this case, if you've got a customer, you've got a contract with them, and you're communicating with them about operational updates, availability of services, delays to services, anything like that, that's an operational update to do with the contract you hold with that individual. And absolutely, you can email that to them and send that to them. That's a necessary update. What you need to be careful of is if you include marketing messages in that, even, you have to keep it purely operational, and not sneak in a little marketing message while you're at it, because that's where they have not given their consent. You'd have a problem because you were contacting them with a marketing message. So it's good to try and separate those communications and make sure that you are, where necessary, communicating key information to your clients and customers as they need it, and then keep marketing messages separate through newsletters and things like that. So absolutely, you can and should be emailing your clients about critical updates, and not failing to do that because you don't think you've got the consent in place, because that's not necessary. One of the other fears, both from within the data broker market and across the marketing world, was looking at how they could source lists of new prospects, and whether or not they'd be able to continue the practice of buying email lists from data brokers. And it's something that, you absolutely can do, but again, you need to make sure that you're doing it in the correct way. So, for example, you can get third-party lead generation, data broker lists, and they who manage it need to ensure that the people who are on those lists are aware that they're on them, and that they've given appropriate permissions to be on that list, and they know what's going to happen with that data. Now, as a person using those lists, what you need to be sure of is that those lists are compliant. So what checks can you do with the data broker about their processes to ensure that they have the right mechanisms in place for getting that data, and that you are sure that they are not on any, for example, telephone preference service lists, anything like that, because if they are, then you need to remove them as well. So you have a responsibility to make some final checks and ensure that you've compared it against opt-out lists that are available publicly for you to do that. but also to ensure that the data brokers are compiling those lists in a fair way. The other element that you need to consider then is the fact that how are you going to use that list, and to make sure that you have that legal purpose for actually using the list. So if necessary, and if you are looking at, for example, contacting people to send them a newsletter, to get them signed up to a newsletter, you might want to approach them initially on the basis of legitimate interests, i.e. they're on this list as individuals who are interested in what you deliver, but then as part of that process ask them to sign up to your newsletter, so that then you're getting consent for the element that you want to be communicating with them on a longer term basis. It's the telephone preference service and the corporate telephone preference service that you would be using to check on the opt-out lists. So I believe that they're available for people to check. I'm not quite sure if there's a charge for that, but those are the official lists that you'd be using to double check that people are not on those lists. And then the other element in line with those data lists is to ensure that you tell people you have their data. So one of the rights under GDPR is the fact that we have the right to be informed that companies are processing our information. So if you buy a list in, what you need to do is within 30 days of having that list is to contact people explaining where you got their data and why you're contacting them and how you're going to engage with them and what the purpose is. You can do it nicely. You can do it as part of that initial contact email. It doesn't have to be official GDPR language. It just needs to be very clear to them where you got the data, why you're contacting them, and the basis on which you're contacting them. So, you believe that they might be interested in your products and services for X because of Y, and you source their data from a list which they were. If they weren't aware that they were on that list, they will no doubt then tell you. So I would suggest that if you have used lists from data brokers for either email or telephone, to double check them, make sure that if they've been added into your CRM system, that you have done that initial communication within the appropriate timescale to tell people that you have their data. And it is something that other European data protection agencies have fined companies for. Our ICO hasn't as of yet, but it's interesting to keep an eye on what's going on across the regulators in case that decision making will be applied more uniformly. So one of the other areas, again, and it's similar in a way to the data broker lists, but is around that calling people, doing telemarketing, and again using potentially third parties to do that. It's the same process. You need to understand why you're processing and justify processing that data. You need to make sure that you're upholding their rights. So again, telling them where you got the data, why you're contacting them, why you think they'd be interested. Again, making sure that they're not on any kind of opt-out list. And then making sure that you've got a good data processing agreement in place with the telemarketing company, so they understand they can only use that data in ways you instruct them, that they're not going to use it for their own purposes, and that they're not going to sell it on to any other company. That's not what you are sharing that for. And that was certainly something that under the old Act, TalkTalk got caught out with, because one of their Indian call centres actually used the data to sell on to another company. In this year, a little story there is the Black Lion Marketing was actually fined £171,000 because they made unsolicited direct marketing calls. Now, the issue there was they made, I think, about 7 million calls that went through. They were outbound calls, but 250,000 of those individuals were actually registered on the telephone preference service and had been for at least 28 days. And that's where it's really key to actually undertake those checks and make sure that your lists and your own data are up to date before you share them with your telemarketing companies, to make sure that those calls are not made to individuals who've actually already previously opted out, because that will land you in hot water. In terms of recontacting old customers, again, this is something that with a careful thought, you're absolutely able to do. So you've engaged with these people, they know you, they have a relationship with you. depending how long ago they engaged with you, you need to think about, will they still remember you? Are they likely to need your services again at this point? At what point, when you haven't heard from them for a long period of time, do you actually say, actually, no, enough's enough, they're unlikely to come back to us? So you need to think then about your sales process. What's your typical sales process? What's your product life or the service that you're offering? How long is it likely to be before people need to hear from you again? And this is particularly where you've had people who've engaged with you and then maybe not for some time. There will be people who will constantly engage with you and you feel confident in your relationship with them. But if you've had a bit of a gap, it's about thinking, well, how realistic is it for me to get back in touch? Would they expect to hear from me? Are we doing anything different that we can tell them about? But make sure that you have a retention period. So, because you have to be realistic, the risk of keeping someone on your list for too long is that you end up with huge amounts of data that you don't know whether it's still up to date, and that's another principle of the GDPR. You don't know if it's still accurate. You don't know if they're likely to come back at all. If it's business data, if the individual's moved on, you could just hold the pure business data rather than the actual individual contact details you've got there. But at some point, I would say there is a point where you have to say, we don't need this anymore. This individual isn't going to connect with us again, and we can remove their details and put them to one side or delete them. Obviously, the other risk is if you hold on to a lot of data for too long, you end up with risks around length of time when responding to subject access requests because you're holding data you don't need, and then that will likely follow with a request for erasure. And yes, you can ask people to opt in regularly. I think it's a good practice to keep in touch with people regularly, and you can do it as an audit check on the details you hold about them as well, and to check that they're still willing and want to hear from you. Some people won't get round to responding. That's life. I think we're all very busy. We all get a lot of emails, and you might get some natural fall away from that. However, it will keep your data generally up to date and better. So by regularly, again, think about how often you're communicating, how you can see whether or not people have engaged with you. But maybe every 2 years, if you've had nothing, that's a point at which you would say, look, and I get these emails come through, you haven't opened our emails, we haven't heard from you in a couple of years, do you still want to get this? And sometimes I'll say yes, and sometimes I'll just let it slide. And that's the way it goes. But you'll have people who are genuinely engaged with you when you're communicating, and that's got to be better for marketing purposes. The other one that we always hear about is data protection in the public domain, and it's in public, I can do what I want with it. Why can't I just contact people? I've had people say, well, they're on the rich list, so surely they're going to want to donate to the charity. It's like, that's not the case. Everybody has a right to privacy. There is information in the public domain, both information that's been placed there by the individual and information that has been amassed and published. And you have to still, if you are going to use this for your purposes, identify that purpose, justify why you're using it, and make sure the individual knows you're going to use their data in that way. So if, for example, somebody comes across our website, it's got our work phone number, it's got my contact details on there, I expect that people will probably email me to my work address to get in touch to find out, do I want their services? Do they want my services? And that's absolutely fine. But again, people should be they shouldn't be absolutely adding me to a database and then me receive their newsletter or routine communications from them without any kind of indication that they're doing that, because I might not be interested. And so it's about a conversation and transparency and making sure people are clear that you've got that information. Again, it might be that you trawl websites and find, here's a subsection of customers that would be really brilliant for me. They're prospects. I want to get in touch with them. If you use that data to pick up the phone and try and get in touch with the individual, you're clear about, I found your data on our website, I want to have a conversation about XYZ. People will say no if they don't want it, or they'll continue the conversation if they do, and that's great. But I would really advise, again, just plonking it into your CRM system, because you're then, until you've got that indicated interest at this point, because you'll end up with a lot of data that you don't need and that you will never properly use, and it just ends up clogging up your system. So really remember that point of, even if it's in the public domain, you have to have a justification for processing it and using it in the way that you want to use it. And absolutely, due diligence is a key point there. I absolutely agree. And this one, so this is something that changed about a year after GDPR came in terms of the guidance that the ICO provided around the storage of cookies. We've all seen the banners that pop up, and most of us probably just ignore them. I actually do click on them and read them and reject ones primarily where they are on news outlets. There's so many tracking ads there. I don't want my data being tracked. However, a lot of companies, smaller businesses, bigger businesses, will also use things like Google Analytics, Facebook Pixel, and again, they are non-essential cookies. They place cookies on our device to track what we're doing and our behaviour, and we need to be able to give consent as to whether that happens. So PECA, which is the Privacy Electronic Communications Regulation, links in with GDPR in that it's adopted the version of the definition of consent for making sure that people have given consent to have cookies placed on their devices. Most websites that I visit in the UK are not compliant. They will still say, by using this website, you are agreeing to the fact that we can put cookies on your device. That's not valid anymore. You absolutely need to review your cookie statements, review your cookie policies. Essential cookies are things like keeping a user logged in, the security of your website, load balancing, making sure that if there's a basket that it remembers what's in the basket, and anything around security, that type of thing. Non-essential will be any tracking, marketing, statistical. We don't have an automatic Google Analytics cookie placed on our website. You have to accept it before that goes on. It affects our ability to see the genuine number of people coming to the website. However, we comply, and I would urge you to look at your cookie consent tool, chat to your web developers, and make sure that that is in place. Yesterday, in fact, the Spanish Data Protection Authority fined Iberian Airlines for incorrect cookie usage on their website. It was still very much not based on consent, and they were placing them without appropriate consent and without appropriate opt-in. You can go in and opt out of cookies once you've given consent. So if you've gone accept all in the past, often, and it should come up relatively routinely. So the ICO are pretty good at this. They will ask, I probably get a request to review it once every 5-6 weeks maybe. It pops up with the cookie again, so however long the cookie lasts, if it's trying to place it new again, it will usually pop up and say to review it even if you've opted in. Obviously, if you opt out, pretty much every time you go to the website, they then ask you, which can be quite annoying. However, it's that balance between how much are you happy to give away about your browsing behaviour to those organisations. And that's absolutely your personal choice, but we should all have that choice. Just in terms of company details and personal details, which I've spotted in the question box there, if you've got pure company information, so just company name, address, and a switchboard number, data protection doesn't apply. But as soon as you put a person's name against that, or a job title which might identify an individual, so Regina Lally at dbxuk.com, that's personal data. It identifies me as an individual as part of that information. It's not just purely company. So hopefully what I've kind of tried to show you there is that if you understand GDPR and you can look at that framework as a way of actually using data in the correct way, it will give you that competitive advantage, simply for the fact that people will value the fact that you are using their data in a way that is clear, it's transparent, that you're respectful of their privacy. And there's a lot of companies out there that don't do that. We all know that. And I think in this day and age, there's so much technology, so much is online, and so much of our lives are online, that if you can really demonstrate you're thinking about how you're using people's data and that you are respectful of what they want, particularly with marketing messages, many more people are aware of this thing called GDPR now, and we're seeing that across the board in things like responses to marketing messages. How did you get my data? I wanted to do a subject access request. All that's coming out of communications that people don't feel that they should have had. So if you can do this well, A, you'll avoid some of those pitfalls, but B, people that you are engaging with will engage with you better and trust you more as a company. And that's a significant advantage over a lot of organisations. And in terms of all four parts of the UK, data protection law applies as standard across the UK. There's no differences there. So thankfully at the minute, it's a little bit easier than trying to figure out COVID restrictions. And obviously the slight difference will come in January when we leave the EU, between ourselves as a whole, as all four parts, and the EU and how data moves between, but that's a whole other webinar, which we do have on our YouTube channel if you would be interested in exploring that. But in terms of the four areas of the UK, we are as one as data protection law. So just to finish off there, a couple of little mini marketing messages from us. This one, we're looking at initiating a data protection best practice group in the next couple of months. And so what I really just wanted to have a test with you now on the webinar is if you'd be interested in sort of getting together, what we're looking to do is to bring together organisations in groups of about 8 to 10, varying different sectors, sizes, etc., to discuss, share issues, ideas around best practice for data protection and applying that in your business on about a 6 monthly basis. And the content would be driven by members, and then we'd facilitate it and obviously put expertise into that. And it would be free to attend. So if you'd be interested in finding out more or us contacting you about that separate to the webinar, please just type yes in the chat box and we'll follow that up afterwards and separately in the next week or so. And yep, so question time. So I can see there's a question there that's just sadly disappearing. So in terms of the staged photos of staff to use on company website or for advertising purposes, again, it's how you want to do that with the employees. So there's a lot of businesses I've worked with where if you're going to use it on a website, sort of meet the team, you know, it makes people more personable. You've got a face to the name. A lot of companies will just do that based on consent. So if anybody really objects to having their photo taken and made available, you kind of actually say, well, that's fair enough. We won't make you do it. If you are looking to actually say that it's standard as far as possible and that you really want it to be done, I would still have it as a separate agreement, because if it's a clause in the contract, in the employee contract, it then comes down to managing that as an HR issue and behaviour, and that could potentially be more tricky. So you could have it as very clearly in a we use your data in this way as a privacy statement, and that if there's any particular issues they have with it, that they can discuss it with you, and it leaves you as an employer more open to that kind of negotiation and discussion, as opposed to you will have this happen, which is probably going to be a bit more productive. In terms of if you've taken stage shots, so for your business and they've been included for a prospectus or in a newsletter and they leave, I think it's one of those things, again, at the point that you're doing it, it's about this is here now. It's not realistic or possible for you to go back and remove them from an organisational prospectus that maybe if they've been, you know, employed for 6 years and then 2 months after you do it, they leave and say, actually, I want myself taken out of that. That's a massive expense for you to then go to. So I think at the point that you are producing those types of materials, it's about saying, once these images are in here, then they are going to be used for the foreseeable future until they're replaced and you can't withdraw your consent. So it's almost like a bit of a model release clause type approach, so that you don't end up with that issue. Is there any other questions at this point in time on what we've covered? As I said, there was a few questions that came in advance that weren't quite marketing related, so I will follow up directly with those via email or a quick call afterwards, but specifically for that and nothing else, unless you've got any other questions. The free trial. A client wants to use a database of school head teachers to offer them a free trial or offer for that is and isn't in GDPR. Emma, is it possible, would you be happy to pick that up separately so that I can just go through a bit more details with you, and we can explore that in a little bit more detail. So in terms of employee permission for photographs in writing, if it's going to be used for more formal prospectus, it's probably good to have that record. If it's on the website and it's a standard kind of, you've got your team photos and these are the members of the team, I wouldn't say that's necessary. I think you can just, by the fact that they're having their photo taken and it's going on the website, and if they can get some kind of editorial oversight of it, I'm sure that's probably enough for most people, but you wouldn't need that to be consent. It'd be legitimate interests, which gives people the option to opt out then if they don't want their photo there. Great. So in terms of social media engagement and contacting people there, people generally, if we think about sort of Twitter, Facebook, Instagram, those social media platforms, that tends to be driven by people following you and then you being able to engage with them on a push basis. And if they direct message you, you can direct message them back. I would just say always be aware of anybody don't ever ask publicly for personal details. Always get that through a direct message or an email that you can follow up separately with. Keep the communication within that platform unless you have a sign up form to something like a newsletter. Similarly with LinkedIn, as much as it's business information, scraping LinkedIn and scraping any of the sites for email addresses is against their terms and conditions, so you should never do that. Make that connection on LinkedIn, start the communication on LinkedIn, and then you can ask to move it to email, telephone, because you're building that relationship. So again, it's being mindful of not taking data from one place and just plonking it into your CRM, newsletter, distribution platform, whatever it might be. Similarly, think carefully before you take your own data and upload it into any of those platforms to do matching. You're then looking very much more at profiling and moving into an area where people might not expect you to use their data in that way. So it's really about, in those circumstances, considering the impact on people's privacy, whether or not you think they'd expect you to use their data in that way. And I always think a good way to think about it is, would I be happy if somebody did that with my personal data? So challenge yourself on that. But certainly being mindful of data protection even in social media is key. But I think generally it will tend to be much more push messages out and then engagement that way. So hopefully that's answered your query. If you did have any other questions, then I'm obviously happy to help. We've got our contact details coming up on the next slide. We do have a range of services that can provide support around data protection, whether that's from sort of marketing queries and questions to helping people manage individual right requests. So we've been quite busy with that over the last 6 months. We've got a toolbox that helps you manage your own data protection program and make sure that you've got something effective implemented, and we can do training as well. So this is a little bit of insight into our approach, and I know certainly a couple of members of our webinars have experienced our training and found it to be useful and go into much more detail on these kind of areas, and we've got the program of those coming up on our website in the next few weeks up to Christmas, and then we'll have more information beyond Christmas in the next few weeks. In terms of, we've had another question come through about a database for a newsletter and how you can use that for marketing. Again, it's very much thinking about what have people given at the point they've signed up for that newsletter. Is it a marketing purpose, or is it a update on operations, that type of thing? If it is a marketing newsletter, you then have to think, have you told people that they might get other marketing communications that's more specific, or was it very much about this one newsletter? Because then you'd have to consider potentially going out to use that list to say, would you be interested in having other communications from us, either via SMS, direct marketing, whatever the channel is you're looking to use and for the reasons you're looking to use. So it's not an automatic, we've got the list, we can use it however we want. You have to think about what people know at the point that they've signed up. Okay, great. That's fine. Hopefully that's all been useful. And thank you very much for your attention. Here's, as I said, just how you can keep in touch with us. If you haven't caught our Data Rockstars Coffee podcast, hopefully tune in on Spotify. It's much more of a random chat. It's what's going on in the news, and hopefully quite fun and engaging. And, you know, it's cool for us. We've got our own little Spotify platform and Apple platform to actually have a little chit chat about all things data protection. So we get a bit ranty rather than quite so instructional or corporate per se. So hopefully it's been useful. Thank you very much for attending and giving up your time. A recording of this will be available on our YouTube channel. Hilary, I did spot your question about YouTube, and I will drop you a message about what you could watch next. And yes, any questions, please get in touch with me at regina.lally@dbxuk.com, or give us a phone call. Kelly obviously will be around as well to help if you have any other questions. And hopefully please connect with me on LinkedIn if you're not already. Thank you, and have a good weekend.